Moore.
More.
Wait, probable cause.
All right, Esteban.
Esteban, Your Honor, no prior failures to appear, no arrests, just a 3. He denies these allegations. Mr. Moore has no prior record, no history of violence. He's not going to be able to make any cash bond. He's not any type of flight risk. I'm appointed through the public defender's office with no failures to appear. He's not going to be going anywhere. My understanding is he never got out of the car in this situation, never had anything to do with what was going on, didn't know that the other people were being serious about what they were going to do. He had nothing to do with this. I think at this point, he was somebody that was in a car and got trapped in a bad situation. So what I'm going to ask you to do is to put a reasonable bond on this. I know it's a murder. You got to do what you got to do, but we're asking him for a reasonable bond.
Are you on this case?
Yes.
Did you want to say anything?
Just briefly from the scene before I pass it over to Detective Pitts. In this case, we would be asking for a high secured bond. The allegations are extremely serious. In this case, there was a planned robbery where someone ended up losing their life as a result of the defendant's actions with his co-defendants. So a high bond is appropriate in this case, but I will pass it over to Detective Pitts.
Your Honor, as you stated, this is a situation where they conspired together to commit a robbery against the decedent and another victim who was involved. And because of the incident, there was a tussle over a firearm, and that resulted in the decedent getting shot as well as one of the co-defendants. So the situation was reviewed by witnesses, part evidence from review of everything in there, as well as statements from co-defendants as well as the witnesses on scene, and it contradicts statements that were made by the defendant right here.
Thank you.
And Your Honor, I would also just be asking for no firearms as a condition of bond.
On the murder charge, $1 million secured plus EMD lockdown plus no firearms. On the aggravated robbery, $500,000 secured plus EMD lockdown plus no firearms.
Grand jury report will be 8/28.
Thank you.
Edwards.
Is that Kara's case?
Yes, the case for yesterday.
We could probably, is someone here for Edwards? All right, we will recall Edwards after. Oh, there she is.
Oh, I'm sorry.
Oh, no, it's fine. I didn't know you were here when I was
I'm
calling.
sorry, it was
All
back
right.
here.
All right. Good morning.
Good
Is
morning, Your
there anything that has changed to review this bond from yesterday?
No, Your Honor, this time I would just wait for the cause into a plea of not guilty and request to make an argument for him again. Unless you remember my argument from yesterday.
I remember the argument from yesterday. The bond will be $10,000 secured plus EMD, which was the bond that was said yesterday.
Thank you.
Thank you. Napier,
Grand jury report on that will be 8/27.
8/20 what?
7.
Thank you.
Brandon, no, let's turn and get that information judge.
good
Good
morning.
morning, Judge.
Waive probable cause.
Waiving probable cause.
Esteban.
Judge, as to bond, Mr. Napier has no failures to appear, Judge, a limited record. Your Honor, he is not a flight risk. His entire family is in the courtroom this morning. Judge, I have known Mr. Napier for quite some time. His family has been nothing but supportive. He was working full-time at Taco Bell, Judge. He denies these allegations, Your Honor, maintains that he was unarmed during this incident. Judge, he was cooperative, went willingly to the district and spoke with detectives and gave a statement, asking the court to take that into consideration this morning in setting bond, asking for a reasonable bond this morning.
From the state?
Your Honor, this is the co-defendant for the case that we heard first this morning. I would be asking for the same bond that was given to Mr. Moore in this case. I believe that is appropriate given the circumstances.
And just add, Your Honor, from our statements with other witnesses and stuff that we spoke with, we were able to determine that he was armed during that incident as well as part of the robbery. And he's one of the individuals that helped conspire with the co-defendants as well.
Thank you. Is he still on probation in juvenile court?
Yes, Judge.
There is a complicity for aggravated robbery that Mr. Napier is currently on probation for, 2 pending charges for assault and receiving stolen property. On the murder, 1.25 million plus EMD lockdown, plus no firearms. On the ag robbery, because Mr. Napier is on probation for a similar charge, 750,000 secured plus EMD lockdown plus no firearms. Sprawl,
Granger, part of that would be 828.
Thank you.
Left. You need a little bit. The button a little bit.
Jaden. Yeah, Jaden. No, I think that's good. Yeah. But no, I got the left knee.
who's on sprawl?
Thank you. Have a good one.
Milo Bachelor?
Can't miss it.
We go to Payne.
Yeah, yes, ma'am.
Who's on Payne? Same.
Kane.
You're on Payne. Thank you.
This one's not. This one's not the strongest.
Got it. Cool. Hey.
Alright. Good morning. Waive probable cause. All right, is there anything from the state? My understanding is this is related to an indictment that related to other charges that are already going through, and this was added, and Mr. Payne turned himself in on the theft charge. Is that correct?
That's correct, Your Honor. We were just asking for a stay away from Home Depot, but I believe that's probably part of the law on the other case.
That's fine.
OR plus stay away from Home Depot.
Thank you.
Miller,
Cool, we don't have to get in about an hour.
right here we go.
Oh, yes. Granger, what would be,
Miller.
or it would be September 2nd.
Miller?
Thank you, Judge. Rich Wendell for Mr. Miller. We've reviewed the allegations and reading relative to probable cause.
Esteban.
Your Honor, thank you. He has a stable address in Reading, 13 East North Street, where he has a heart. He's a wither of day, with ties to the community, including family ties. He could afford a very modest cash bond. Judge would request fair and reasonable bond.
From the state,
Your Honor, this occurred back in July 25th. There is video footage showing the defendant using a firearm in this case where he shot the victim in the leg. The victim did have to go to the hospital due to his injuries. The defendant is under disability due to an aggravated assault from 2022. So I would be asking for a high secured bond in this case, as well as no firearm as a condition of bond.
there's one violent felony, one violent misdemeanor, 2 misdemeanors, 6 prior failures to appear. On the having weapons under disability, 50,000 secured plus EMD lockdown plus no firearms. On the felonious assault, 750,000 secured plus EMD lockdown plus no firearms. Barnes,
The report on that will be 8/28.
828.
good morning. This is just a traffic.
Hey, Barnes, Your Honor. Right middle, just wondering, there's a wait on that. Now, real quick. Guilty plea, Judge.
Mr. Barnes, a guilty plea is a complete admission of guilt. This is a minor misdemeanor. Maximum possible penalty is a $150 fine plus cost. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties. Do you want to maintain a guilty plea to operating a vehicle without without an
It's having a
instruction from it?
temporary instruction, Judge, and operating the vehicle between midnight and 6 a.m.
Do you want to maintain a guilty plea?
Yes.
All right, you waive and stipulate.
Wait a second.
Mr. Barnes has been here one night.
Yes,
Is there anything else?
Your Honor, he's being held on another case, can't make a call, he's been in for about a week, so.
Is there anything from the state?
No, Your Honor.
1, credit 1, remit the fines and costs. Sprawl.
Sprawl. Sprawl, the man, go right in the middle, attorney, you have to wait on full attention as you face the judge.
Good morning, Judge. Jamila Bashir on behalf of Mr. Sprawl, Judge, we will waive probable cause and ask him for a bond. As the bond, Your Honor, Mr. Sprawl is 24 years old. I would note that this appears to be a delayed disclosure. The allegations here are from 2020. At that time, Mr. Sprawl was actually a high school senior. He did ultimately graduate. He's worked and maintained employment for the last 2.5 years. He has been raised by his grandmother. He does have family support. His family has also cooperated with this investigation. I have questions about the conditions of these alleged admissions. There was no attorney present, Judge. I will submit that to the court and ask the court to impose a reasonable bond. I do understand these are serious charges.
From the state.
Your Honor, we would be asking for a high secured bond. In this case, the allegations are extremely serious. The victim in this case was 11 years old at the time. The defendant did admit to receiving oral sex from the victim as well as performing oral sex on the victim. Again, that victim is only 11 years old. I think a high secured bond in this case would be appropriate.
$250,000 secured on each count plus EMD plus jurors. Carter,
Grand jury date on that will be 8/28.
Oh, wait. Mr. Carter?
thank you.
It's pretty next for you tonight.
More judge. I've got no here.
Gabriella Biddle, has to,
Please, ask the bond, we were in court last week in front of Judge Greenberg. Originally, there had been an order to have no contact with these middle and children. We requested that that portion involving the children be removed.
he made a note of it.
And I have a copy of the order. And he did make that order, and at that point, I suggested to Anthony that he contact the third party in order to have contact with his children. His mother called on Friday, so he could do things for school. He declined to let him see the children. Saturday, his son plays football. He is one of the coaches. He went to the game to watch. He was not coaching. He stayed away from it. He was in one corner of the football stadium. She was in the other corner. He didn't know she was there. There were 250 people watching the game. He was there with his mother. Early in the second quarter, he saw her starting to walk across the field on the other side. He decided at that point to leave, and he did leave. He contacted him immediately. I said, if the police contact you, have them get in touch with me. He did not. It seems to me that if she doesn't want him to see the children, all she has to do is be with the children when they go to an event that involves the children. So it's kind of a trap for him. So I suggested that maybe we go back to Judge Greenberg and see what we can do. I can't estimate how far away they were from each other. Standard football field, as you know, is 100 yards, 300 feet. She was in the far corner. The football stadium, or the field itself, is 160 feet wide. So they probably were 350 to 500 feet apart from each other. When he saw her, he did not know that a charge had been filed. He reported for probation yesterday. He was arrested. He's been employed at the Free Store now for the last 6 years. He understands that he's to have no contact with her, but we're going to have to do something to clear this business up about the kids, because in essence, it's a trap. And if you can't see the kids, what he's going to have to do, he does not have a paternity declaration on these children. I've suggested that we're going to have to file paternity in order to get visitation, and then we can do it that way. Until then, it's going to be a problem, because I think there's a lot of hard feelings here, and I'm not here to criticize her necessarily. She's wanted to move to California. He does not want her to leave the jurisdiction because there's 2 children here. So this is going to have to be hashed out in court, probably over in juvenile court. So what I'm going to do is ask you to give him an OR bond. He understands it's to have no contact. We'll see what we can do with Judge Greenberg, so we can fashion something so he can see the children, so this won't occur again.
I have a question. Can somebody check that? Yes.
Maybe I can answer what's your question.
It should be 331. Okay. I had the protection order expired, so somebody must have typed it in wrong.
We'll move for dismissal.
Not that easy.
Well, it should be.
We found the proper one. All right, from the state.
Well, in the spirit of conciliation, we would ask the court to do this.
From the state.
Judge, for the city, looks like the underlying offense was Judge Harris's protection order on a county case. We would defer to you on possibly going back to the judge, the other judge, trying to get the modified if possible.
Judge, we are scheduled to be back in front of Judge Greenberg on the 28th of this month, so if you can just
vote on there, set it for pretrial on the 28th.
That date is a pretrial.
So 8/28. Thank you.
On the trespass, I will reinstate the original bond. And then OR on the violation of a protection. City domestic violence docket.
What is the original? What is the original? This is Blessing.
Brutal got dropped. Criminal trespass, DV, and
Hold on, let me see.
then they added enactments.
Hold on for, what is
Was the, I'm sorry,
the original bond on this? On the trespass, it was 5,000 plus EMD. Yeah. So for the bond rep, I just reinstated the original.
Anything all day.
There's a low bond. All right, on Crump,
No.
Morning, Judge.
good morning.
Trump? Mamadou Day, present? Mamadou Day? Right.
Yes.
Is this a Crump?
It's not.
Okay.
Your Honor, Lee talked on behalf of Ms. Crump today. She is already represented. I have designated her other attorney. As to bond, please not guilty. As to bond, she does work. She works at Target. She's part-time. She's been there just a short amount of time, so she's anxious to keep her job. She does have an evaluation as well for mental health assessment. It's actually at 1:30 p.m. today at UC. She does suffer some depression issues. She's hoping to get on some medication to help that. While she does have a minor record, she has no failures to appear. I've been in touch with her attorney. He has good contact information. She knows how to get a hold of him as well. This is a violation of protection order. She understands not to have any contact. We talked extensively about that. Even if he contacts her, which is I think the case here, she needs to stay away and she will do that. So we are asking the court to consider an OR, SOR, or perhaps an OR EMD alternative.
From the state.
Just ask for the continued stay away and also stay away from that address, 2731 East Tower Drive.
OR plus stay away. Holloway,
She's OR. Ms. Holloway.
Eric Williams, present? Eric Williams?
Are you Mr. Williams?
Go right in the middle.
Oh, okay, okay.
Little attention, basically.
No, it's something. Not guilty, Your Honor. As to bond, Ms. Holloway, we did talk about the protection order. She's okay with that. She is asking because she does live with this person for box 13 to be checked so that she can retrieve her personal items.
Yes.
Thank you. Your Honor, she's 39 years old, no failures to appear. I don't see any record at all. That's why she has no failures to appear. She has 2 children. They're 11 and 12. She'll be staying with family and friends here in Cincinnati. She has plenty of people that she can stay with. Main concern is she's been at the United States Postal Service for the last 8 years. She was due in at 8 a.m. today, and she wants to get back to that, obviously. So she is asking the court to consider an OR. We talked about that stay away or temporary protection order, and she understands it.
from the state.
No objection to the OR, as long as there's a stay away, Judge.
OR plus the TPO. Moses,
Oh, it's still up.
Alexis Walker present.
Mr. Moses.
Alexis Walker.
Come out and go right in the middle, Mr. Attorney. Full attention, make you face the judge, okay?
Not guilty for Mr. Moses.
all right, Esteban,
Yes, Your Honor, Esteban, Mr. Moses is going to be signing a temporary protection order. He will stay away. While I will note, he does have quite a number of failures to appear on his record. I spoke with him about that. Those were some pending traffic matters. He doesn't fail to appear on his actual criminal matters. He has resolved all those traffic matters at this time as well. He works, he's a machine operator at Oates overnight. He's also set to start school at Cincinnati State to get a mechanical engineering degree. Lifelong resident of the area. He's staying in Bond Hill with a friend. Understands the TPO, will stay away, asking the court to take that into consideration. With those failures to appear, if you are inclined to give him a cash bond, we're asking for no argument.
from the state.
Judge, according to the facts written by the police, victim stated to them that the defendant picked up the victim and slammed her on the floor, and then he took an electric fan and struck the victim in the head with it. So we'd ask for a reasonable bond and to stay away. Which I think is considered.
He did sign a
Thank you.
TPO.
Thank
As has already been alluded to, Mr. Moses has 14 prior failures to appear. While the court understands the traffic argument, this court also is of the opinion that if someone does not show up to court when they cannot go to jail, that they will probably not show up when they can. He does not have a record. And it looks like there has never been any charges of this kind. It will be $5,000 anyway, plus EMD, open hours, plus juris if requested. Felony lockup docket. Connor, I'm sorry, Addis.
Sure, Megan, Connor, Mr. Addis. Right in the middle, next to your attorney, full attention, make you face the judge.
Thank you.
Morning, Judge. We will waive probable cause and ask to be heard on bond.
Esteban.
As the bond, Your Honor, Mr. Addis is 23 years old. He has no violent convictions, no felony convictions, or a score of 2, only 1 failure to appear. Judge, his primary source of income as of now is SSI. He's been getting that since he was 19 years old. Judge, all of this transpired on Monday night. He was in the hospital all day Tuesday, and then ultimately found out about these charges, and they brought him here to the Justice Center. Judge, I know that there's a pretty lengthy narrative of what is alleged to have occurred that night, and it's based on all of that. It sounds like Mr. Addis his biggest concern is mental health here. I did have him connected to our social services this morning. They've already talked about a plan should Mr. Addis be released. There are services that are just a 5-minute plus ride from his house. His other concern as of now is his 3-year-old dog that has been in his apartment now since Monday with no one to care for that dog. He actually asked the officers to call animal control, and they told him that he would be back home to care for his dog. Obviously, that wasn't the case. Judge, we're looking at an F3 and actually an N1 before the court this morning, so I would ask the court to consider all of that. There is no monetary bond that he can post at this time. He can, be on EMD, and he does have relatives who can confirm his address for the EMD.
From the state.
Your Honor, I would be asking for a high bond in this case. There was a shot spotter alert for 5 gunshots. They received a call from the defendant who contacted dispatch and made statements threatening suicide by cop when cops were out. The defendant had a knife. He yelled at officers to come on down here with the knife. Eventually, they were able to have him drop the knife and get him into custody. They found casings in the area where Mr. Addis was found. They found ammunition matching those casings in the kitchen. They then eventually found the firearm that was used after the defendant admitted to hiding the firearm in a trash can in the laundry room of the apartment complex. These allegations are very concerning, so I do believe a high bond is appropriate, as well as no firearms as a condition of bond.
On the F3 tampering, 15,000 anyway. On the M1 discharging a firearm, on the misdemeanor, 5,000 anyway. Alexander.
Grand jury will be 828.
There's a Claremont County.
Is it on everything?
Yes.
Good morning, Your Honor. I'm submitting Terry Cranmer's designation for Mr. Alexander, the felony is.
Right in the middle next to your attorney, you have to wait on me here in a second.
We can waive probable cause. Bond, Your Honor. Mr. Alexander is 21 years old. He's a graduate of Reading High School. He's currently not working, so doesn't have a lot of money to post bond. My paperwork shows 0 failures to appear in Hamilton County and an ORAS score of 3. He is going to be offered treatment, Your Honor.
From the state.
I would defer on bond.
There's a Claremont County holder.
That's good.
On the obstruction, it'll be the standard bond, 1,000 anyway. On the B, it'll be the standard bond, 500 anyway. And on the F5, 1,000 anyway.
Grand jury report will be 828.
Anderson.
You were ready again? Ms. Anderson? Man, come on out. Yeah, right in the middle, in between attorneys, you're gonna be able to wait for me.
Good morning, Your Honor.
Good morning. Waive probable cause.
Yeah, I'll raise the vehicle calls.
As defined.
As defined, my client's 59 years old, a lifelong resident of Cincinnati. She works at North Manufacturing, and assembler. She went to North College Hill, through the 11th grade, has 2 grown children and 3 grandchildren. I believe she was on probation to Judge Jenkins. I don't know if there's a probation violation that's been filed in that case at this point, but she has 2024 that she's on probation for possession. She had one in 2012. She has 1 failure to appear in the last 5 years, and then her overall score is 4. Your Honor, in order for her to keep her job and such, even an alternate bond, EMD, would be appreciated.
On the misdemeanor,
She'd like to resolve the 2024 traffic series. Can she plead to 1?
Yeah, she wants to plead to the A, we can just.
Thank you. Guilty to the A.
and is that unclassified?
Yes, Your Honor.
Alright. Ms. Anderson, a guilty plea is a complete admission of guilt. The driving under FRA suspension is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to the 1 count of driving under suspension? All right, Counselor, do you waive and stipulate?
We'll waive and stipulate, yes.
Finding of guilty, she has 1 night credit.
She does.
Is there anything else in mitigation?
Just that she is indigent, she qualifies for our representation, so asking for credit for that.
From the state, anything?
Nothing from the state.
1, credit 1, remit the fines and costs. Was there FRA compliance? Was there accident?
No accidents,
No.
FRA emergency.
On the other charge, there is 1 failure to appear, which was the one that was just taken care of. It looks like on the cases from 24 that Ms. Anderson had, there aren't any failures to appear. On the M4, the traffic, and the F5 OR supervisor.
Grand jury report on that will be
Brown,
9-2.
Speaking lady, last one, order supervised. Johnny Brown. Brown? Johnny Brown? Yes, sir, no?
Good morning, Your Honor.
good morning.
We are going to waive probable cause and a plea of not guilty.
Ask Bonnie.
Thank you, Your Honor. As to bond, Johnny is 64 years old, lifelong resident of Cincinnati, graduated from Hughes High School, does still currently live here in Cincinnati. He's got family here, Your Honor. He is receiving disability, about $1,000 a month. Your Honor, that's from a severe injury he faced back in 2013. He also needs a hernia operation and has high blood pressure. Your Honor, he does have a daughter and grandson he sees often. Your Honor, as to this allegation, it looks like there's an allegation of trafficking and possession. I do want the court to know, my client was handcuffed when police officers tased him 5 or 6 times. I don't know that that was appropriate. Last conviction here was in 2011. 0 failures to appear. Because he's on disability, I'm going to ask for a supervised bond. The court wouldn't consider that. I'd ask you to consider some kind of EMU supervision.
From the state,
Your Honor, the defendant does have prior trafficking convictions, prior felony convictions. In this case, he did try to swallow the suspected cocaine when officers were apprehending him. He was found with an F3 amount and was engaged in hand-to-hand drug transactions as viewed by the officer, so I would ask for a monetary bond in this case.
There are 3 violent felonies, 8 felonies, 11 misdemeanors. It'll be the standard bond and the obstruction, which is 1,000 anyway. The F3 tampering, 2,500 anyway. The trafficking, 5,000 anyway. The possession, 2,500 anyway. Davis.
Grand jury report will be 828.
Davis. Go. Right in the middle, your attorney's gonna meet you.
Sir, thank you for Mr. Davis. We have reviewed the allegations and would waive any additional.
Probable cause as to bond.
Thank you, Judge. Judge, he has good community ties. He's full-time employed, has a 7-month tenure at an establishment at the bank's stable address in the county with his mother. It's my understanding he does not have funds for any cash bond. Judge, we would request, in light of those facts, fair and reasonable bond, potentially some form of alternate electronic monitoring, maybe appropriate.
From the state.
Your Honor, these allegations involve fentanyl, an F2 amount, 13 grams. Mr. Davis was also found with a firearm. He was under disability due to a trafficking and cocaine conviction in 2010. I would ask for a high bond in this case based on this fact.
I believe the TRD series goes with it too. Yes. Thank you.
The trafficking is a F1.
Yes, I believe they're saying it was within a class of years.
On the having weapons under disability, there is a prior conviction for the same offense. That one is 25,000 secured. On the traffic offenses, OR. On the carrying a concealed weapon, 15,000 anyway. On the trafficking and fentanyl, 25,000 secured. On the possession, 25,000 anyway.
Grand jury report will be 828.
And give me,
Do you want that on everything?
Yes.
give me 1 minute, I have it.
Court is in recess.
What'd you say?
They could, huh?
Yeah.
Hold on.
No, right there.
Yeah. I won't be here Friday or next week.
So I don't know. I know you guys did.
So, well, I texted Jim Costa. I said it's difficult. I have him on.
Amy Marie.
He should be on.
Okay. I would, yeah, we were.
Either way, I'll be on it, but.
Before it made it to.
Actually, to believe all of our sheets are going
Well, then next you can take your week off. Gotta pay your back.
Yeah. He's probably better today, but we'll see.
I don't know if she texted
I was, when I read it,
I think she called it. Into the house, into the car. I know, right? This was years ago. It was fun. You're only
So he was.
So my wife's. I had to go to the bottom of the service station. I was going to this place.
Oh, it's reading. Today's his probation.
Literally worked.
It's,
It's typically needs wrong training, that's all.
I'm confused about the whole thing too. I'm not really sure what's going on, why he's here. But it's okay. We'll get it set in Paris.
Yep, thank you.
Straighten it out.
I'll split it with you. You just, he said, okay, that's fine. He called me later. He said, hey, Rich. I said, absolutely. I said, somebody will give it to you. I said, that's what you and he got the labor down, rebuilt it.
That's Fred Cohen again. This is. They don't know, you don't know. Yes.
It's a hobby for him. It's just pure fat, everything flat. So, good, and you know that. Sure. You said it here, this is the least corrective. Barely fit to.
Right.
That's correct.
Phil, that's conversation with county director and assistant director.
Alexander.
Tell them that. Actually, yeah. Yeah, I like that. She'll be here Friday and on next week.
It's better.
So you get Ashley.
You're going
I'm going to Jack. I am. I really am. I'm sorry.
That's called hard.
She'll talk to you guys at least.
Yeah.
So we say hi.
I was giving it.
No, she's hilarious. And you can read it on her face if she really doesn't know. Like, she's not gonna bullshit it.
Rather you be honest though, try to beat us through.
Yeah, she'll be like, yeah, no idea.
So, we come going? Oh, there it is. Yeah.
It was second kid. This girl's name.
Have you worked that up? Could ask.
Well, he was on the witnesses. He was just.
Court is back in session.
Hall,
Scott. Hall, sorry.
Mr. Hall? Yes, sir. Yes, sir. Yes, sir. We're not right in the middle of this turning, and we have to wait on.
Waive the reading of the probable cause.
Esteban.
Esteban, my client's 34 years old, lifelong resident of Cincinnati, graduated from Woodward High School. He has an 8-year-old boy. He is employed, has 2 different jobs that he does. He works doing demolition for Mr. Rumpke. And then when this slows down, he does landscaping with Urban Lawn Care. I note that he has an ORA score of 1, 0 players group here. He did have a couple of priors, I guess 2015, 2025. Just ask Your Honor for maybe OREMD or so he can continue working.
From the state,
There is a tracking in fentanyl from 2025. The allegations involve cocaine. I would be asking for a monetary bond.
oh, that's pending. $5,000 anyway on each count plus EMD. Harris,
Grand jury, that will be 828.
But it's not related to this. Okay. Okay.
It's from June.
Harris.
Good, thank you, Mr. Harris.
I have probable cause.
We have reviewed the complaints, thank you.
Esteban.
Judge, thank you. Judge, he has a good, stable address in the county with family, good family ties in the community. We would request fair and reasonable bond on the felons. And it's my understanding the TRD series is unrelated.
That is correct. Not guilty plea on that, Your Honor.
Alright. From the state,
There Your Honor, these charges are based on this residential search warrant. I believe the tampering is from a traffic stop when the defendant threw out purple liquid, which they believe to be fentanyl, out of a cup when they were pulling him over. Out the window, there was a firearm that was recovered in the defendant's bedroom during the search warrant. He is under disability due to a prior conviction for possession of cocaine in 2023. Based on the number of charges and the amount of drugs that were found, I would ask for a high bond in this case.
Ice. On the having weapons under disability, it looks like this is a first one, 15,000 secured. On the trafficking, and cocaine. Let me go through this. There's 2 felonies, 3 misdemeanors, 12 failures to appear, and pending charges in Ohio, and it looks like Kentucky. On the trafficking, the C trafficking and crack cocaine, which is in F. Yeah, the trafficking and cocaine was an F4. The trafficking and crack cocaine is amounts F2. 20,000 secure. On the trafficking in fentanyl, which is an F4. $10,000 secured. On the F2 possession, 20,000 secured. On the F5 possession, 5,000 secured. On the F4 possession, 10,000 secured. On the F4 cocaine possession, 5,000 secured. On the tampering, 5,000 anyway. On each of the tampering charges, and the failure to comply, $5,000 secured.
Trafficking and cocaine, I believe the B count was, I believe that's the only one I did not hear.
The B count is 10,000 secured. And then on the 26 traffic unrelated to this, the child restraint violation, OR, the driving under OVI suspension, based on the bonds that were set, do you want a nominal bond?
Please, thank you.
500 anyway. Right, heist,
Grand jury report on this felonies will be 8/28.
Oh, everything.
Just the felonies.
Just the phone.
Not
Okay.
We'll have to get back in. Ice. Bill, next to your attorney can meet you up in a second.
Wait, reading of the problem calls.
Right, as defined.
Esteban, my client is 43 years old. He's a lifelong resident of Cincinnati area. He grew up in Fort Wright, Kentucky. Graduated from Scott High School. He has two children aged 8 and 17, soon to be 18. He's done management work, Your Honor, but currently unemployed. I showed no prior contacts in the county and the information I've been given, and then in northern Kentucky, I showed that he's had some misdemeanors, but I don't see any felonies. He has 0 failure to appear. I don't think he got interviewed. I think for some reason he had on a raw score, but there was something noted about maybe something in Kentucky, but he had an EPO that was dropped, is my understanding. Nothing's pending for us on that. We would ask for an OR bond on it.
In the state,
deferred.
supervised to OR on the F5.
Thank you, Your Honor.
Grand jury amount would be 9/2.
Holly,
Judge, he's being really good.
he's been waived today. We're moving this to tomorrow.
We're done.
Continue to not 8:20 at 9 a.m. Lewis,
Now, Mr. Lewis,
Now, it's
right in the middle, and in between your trees, you got your hand in the second wing, my God.
right here.
Your Honor, we're gonna waive probable cause and plead not guilty.
all right, as to bond.
Thank you, Your Honor. Esteban, Sebastian is 26 years old, Your Honor, lifelong resident, graduated from Woodrow High School. Your Honor, I do want to say, first off, he has an alternative address. That's with his mother here in Cincinnati. He is willing to sign the temporary protection order. I did go over that with him. He understands the terms of that. Your Honor, he also turned himself in. This is someone at 26 with 0 criminal record, no failures to appear. I know that ORA score was 5. How they got there was his age, the fact that he missed might have missed, I think he did miss actually a traffic ticket, Your Honor, in the past, and that he's currently not employed. I can tell you he is actively looking for a job. He has been for the past 2 months, been applying for different warehouse and restaurant jobs. We'll stay away from this individual, Your Honor. As I said, he has somewhere else to go.
From the state,
Under this altercation started over cheating allegations. The defendant and the prosecuting witness in this case have a child in common. During their argument, the defendant struck the prosecuting witness multiple times in her face with a closed fist. This caused her to stumble backwards. He then pushed her onto the ground and placed his hands around her neck, strangling her. She stated that she could not breathe during this. She then was able to get up and run to a neighbor's house to get away from the defendant. Officers, when they talked to her, observed a visible bruising and a swollen eye, bruising and cuts to her neck, right arm, and chest. Based on these allegations, I would ask for a monetary bond as well as for the TPO to be executed.
has the TPO been executed?
Yes, Your Honor.
And then on the other traffic,
That's an unclassified, we'd like to enter a guilty plea with that, Your Honor.
Mr. Lewis, a guilty plea is a complete admission of guilt. This is an unclassified misdemeanor. Maximum possible penalty is up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to driving under suspension?
Yes.
You waive and stipulate
We do, Your Honor.
finding of guilty. He's been in one night.
He's been in one night. He knows what he needs to do to get his license, and he is indigent. We're asking if you take that into consideration.
Anything from the state?
FRA was marked no.
Credit one, remit the fines and costs. Mr. Lewis does not have any record as an adult or juvenile. No failures to appear, no prior charges. $2,500 anyway on each count, plus juries if requested.
Grand jury report will be 8/28.
McClellan,
What was, I'm sorry, I just made.
8/28.
Sure, we'll go right back in. Well, will attorney be waiting on here for a second?
We'll waive the reading of the probable cause statement.
Esteban, my client's 36 years old, he's a lifelong resident of Cincinnati, graduated from Indian Hills High School. He has two daughters, aged 10 and 8, that live with him. He does landscaping for Bennett Landscaping. I show that he has an aura score of 1, 0 failures to appear. He did have some priors in 2021 and 2011, it looks like, Your Honor. Asking for to take into consideration setting a bond, possibly no warrant.
from the state.
Your Honor, I will observe that he does have prior trafficking and possession convictions in cocaine, and prior trafficking in marijuana. Will defer.
There's 5 felonies, 1 misdemeanor, 0 failures to appear. Both of these are F3s.
There you go. You want to take the phone, put it on my phone.
$10,000 anyway on each count, OR on the traffic. Minifield,
Grand jury report will be 8.
Thank you.
Davis and Hall.
8/28.
Isn't Bill? Let me come up and report on through. Give one, each got one there.
Judge, I am actually going to challenge in this case.
on both or just?
On both.
One? Alright.
Your Honor, on or about August 19th, 2026 in Hamilton County, state of Ohio. The defendant carried on his right hip a black Ruger handgun. After officers asked if there were any firearms and the defendant, it looks like,
Smithfield.
confirmed that there were no weapons. It looks like he had an open domestic violence warrant at the time. That's all I have, Your Honor.
From those facts, what makes this an F3?
The weapons under.
No, the CCW.
Your Honor, based on these facts, I'm honestly not sure. I don't have much information. I don't see, at least in Hamilton County, him being under disability. Or disqualified from carrying concealed, so not sure.
On the CCW, I find probable cause for a CCW charge. I do not know what the level is based on. It looks like a misdemeanor to me at this point, and I will address it as such. On the weapons under, the state does not see a disability. Mr. Minifield has no record as an adult, one misdemeanor as and it is not violent, as a juvenile. There is nothing else. Is there anything that the state has that places him under a disability?
Not at this time, Your Honor.
Probable cause not found on the having weapons under. As to bond on the, is there anything from the state on the CCW?
In terms of bond,
Mm-hmm.
I would just ask for no firearms as a condition of bond.
4. Mills,
Grand jury on that would be 9-3.
What day?
9-3.
I'm submitting your designation for the felonies and the obstructing official business charge. Felony appropriate for drug court.
Middle and next your turn.
We'll wait for our call.
as the bond.
Coach, he is 36 years old, he's an NKU graduate, he's been in this area his whole life. I know that the bond preference indicates defer to the prosecutor, and again, he's gonna be offered treatment, and it's likely to be outpatient treatment at first. We'd have to consider supervised OR.
From the state.
Defer.
On the capias.
Your Honor, yes, with regards to the case, it's gonna be a not guilty on the 25 series and the 26 series. The additional 26 series, I will note, is an allegation from June that wasn't filed until mid to late July. That's on the theft charge, Judge. With that being said, the other thing I feel should be of note is that the bond I see of 10,000 was put in by a magistrate. I'm gonna ask the court for a supervised OR bond, so that way Mr. Mills can go through the process of drug court accordingly. I'm not sure if it was also addressed, but we do have good contact information for him as well. As the fact that he has lived here and he is trying to support 2 children.
So the theft is unrelated.
Correct.
Does the state have anything on the misdemeanors?
Just say when please from Family Dollar stores. That's all we have.
On the 5-5, there are 2 violent felonies, 6 felonies, 5 misdemeanors, 7 failures to appear. On the 5-5-1-7 drug paraphernalia, I will modify that to OR, because those are magistrate's bonds. On the 6-7-9-9, I will put the bond back to what the trial judge set, which was 500 anyway. On the theft, the standard bond, 1,000 anyway. On the tampering, $5,000 anyway. On the F5 possession, 2,500 anyway. The court is not doing EMD because Mr. Mills has not been successful on EMD per the EMD stats that I've been provided. On the obstruction misdemeanor, 1,000 anyway. On the felony illegal conveyance, 15,000 anyway. Edsel,
Did you say, I didn't catch the last one?
15,000 anyway.
Grand jury report will be 8/28.
Edsel.
Megan, you get that.
Thank you.
You're welcome.
Waive probable cause.
I do not, Your Honor.
All right. Can we hear it?
Your Honor, on or about August 4th, 2026, in Hamilton County, state of Ohio, the defendant did by force trespass in 2439 Moreland Avenue, an occupied structure. Based on victim statement, it looks like the suspect forced their way into victim's residence by shoving the front door open to gain entry.
Your Honor. The statute requires to commit a criminal offense is entitled to notice the complaint should be obtained what that criminal offense is. Number one. Number two, I know we're not here to try this case, but I did show the state of Ohio videos of the incident. My client never left the sidewalk when her friend banged on the door after the woman had backed into my client's car and then fled. So the client would come back out. Nothing more. I think she called the police because she didn't want to answer the scene without exchanging information if I had to. In any event, the client had no record of the crime. But again, probable cause, I think, was not met in the absence of some allegation of a criminal offense other than criminal trespass, which is an element of defense.
From the state.
Your Honor, based on the complaint and report, it looks like there was the victims were parallel parking. They claimed that two vehicles behind them got into an accident and reportedly blamed the victims for the accident. The victims ran into their home. The defendant, two suspects, ran up to the door and tried to push the door to get into the home. They were pulled away by their friends. In this case, I would be asking for a stay away from the prosecuting witness's residence and the prosecuting witnesses in this case, which looks like is where this incident happened. My other concern is that the defendant has two assaults currently pending in municipal court at the moment.
I can't disprove negative, Your Honor. She's not been convicted of number one. Number two, again, there's a missing element.
Probable cause not demonstrated or Robinson.
Grand jury date on that will be 9/2.
Oh, Robin.
Yes, sir.
We're gonna waive probable cause or plea of not guilty.
Ask the bond.
I do want to let the court know, I believe one of the alleged victims is here.
Yes, ma'am. What's your name? If you would speak into the box, please.
I'm Don Cole, whose car was taken. And I'm just saying, I don't mind if the charges are dropped. He's already did over 60 days in Kentucky.
So once they're filed, it becomes the state's case. Do you have a position on bond? Thank you, ma'am. All right.
Thank you, Judge. So to start, Judge, that's correct. This charge was also related to an RSP over in Kentucky. My client did provide me a copy of the plea agreement. I do have that if the court wants to see it. It shows that he pled guilty to a misdemeanor RSP, received 90 days in jail and a $250 fine.
Is that the Boone County one that you
Yes.
just got out on?
Yes, Your
Okay.
Honor.
I don't
So-
need to see it.
You said you don't need to see it.
No, I have it.
Okay. Your Honor, so we do have that. I tend to think that's gonna be ignored. As to the other charge, Your Honor, my client, I believe, is gonna have an alibi for that case. He remembers that day and knows that he was doing an event for a book he authored that day. Your Honor, I'd ask you to also consider he's a lifelong resident, has a good address here in Cincinnati with his mother. Your Honor, hasn't been in trouble for a while, I think at least 4 years, with the exception of this car incident. Your Honor, I'm asking you to consider an OR. It's a nonviolent offense. He'll stay away from Macy's. That's not a problem.
From the state.
Your Honor, this is a theft from Macy's as well as a theft of the motor vehicle, and in this case, we would be asking for a stay away from all Macy's locations.
On the vehicle theft that the prosecuting witness is here on, it'll be an OR bond. On the Macy's theft, it'll be OR EMD. There are 22 felonies, 5 misdemeanors, and a failure to appear. So the court is not doing a straight away. It'll be OR EMD open hours. Terry?
We're in for will be 828.
Go home, you have to get the ankle bracelet out tomorrow, not today.
Your for the felony and then the misdemeanors ending in 16302, we are asking for a 1-day continuance because it's my understanding Ms. Terry is in the hospital.
Continue.
Not on mine, no, Judge.
Thank you.
Are you arguing the first district case at this time?
I will eventually, yes.
Okay.
Your Honor, you're 2 steps ahead of me. I'm going to maintain the not guilty at this moment in time. The allegation here is directly on point with the case that just came out of the first district.
Would ask you just to be transferred to a trial or take a look at it.
OR.
Thanks, Judge.
It's too early for a constitution.
Whitaker?
Mr. Whitaker, you want
Are you here on Whitaker, ma'am? Oh. I'm sorry? Okay, you have a seat. The deputies will call. We still have some other cases that we have to go through as well. Thank you. You're here on Whitaker? Are you a witness or a victim, or you're just here to support? Okay. His attorney will come out and talk to you. All right, thank you, ma'am. All right,
Thank you, Your Honor. Waive probable cause, not guilty.
pass the phone.
Thank you, Judge. Esteban, Trevor's 41 years old, Judge, lifelong resident of Cincinnati. He does reside with his mother, who appears to be here. He is self-employed as a mechanic, been doing that for over 20 years. Scarlet Oaks High School graduate, Your Honor. He does have a 21-year-old son he still supports. He does have diabetes, takes insulin for that. It's been a few years since I see that he's been in some trouble. I know he has a few failures to appear. Those were on traffic tickets that he has since resolved, Your Honor. He took care of those. Judge, I think he could afford maybe between $500 to $1,000 at the most, but that's about it. He tells me he wasn't violent with the officers. There was not a crash. He, I think, only got a couple miles down the road. I ask you to take all that into consideration.
From the state?
Your Honor, the defendant was pulled over for a traffic stop. When officers saw in the car what they believed to be drugs, they asked the defendant about them and he took off. eventually they were able to pull him over. Obviously now he's been charged with possession of what they believe to be methamphetamine, failure to comply and obstructing. Based on him fleeing, I would ask for a monetary bond in this case.
Judge, I apologize, I left out one thing. They charged him with 2 failure to comply. One's a felony, one's a misdemeanor. I don't see an allegation of different conduct for each, so I just wanted to point that out.
There is 1 felony, 1 misdemeanor, 4 prior failures to appear. Does the state have any information on the failure to comply, or is, as far as, are these just charged in the alternative?
I believe they're charged in the alternative.
On the drug paraphernalia, is that a M? Oh.
They charged us an M4, Your Honor.
Thank you. 500 anyway or alternative OREMD. On the felony and misdemeanor failure to comply, 5,000 anyway on each or alternative OREMD. On the reckless operation, which is a minor misdemeanor, the seatbelt and the rear lights OR. On the F3, $5,000 anyway. On the tampering, 2,500 anyway. On the obstruction, 1,000 anyway. Bazali,
Grand jury report will be 828.
All right, good morning again, Judge.
Go to Dr. Mom.
Judge, I am going to temporarily submit my designation. This is going to be transferred over to Mr. Jesse Jackson. I did speak with Jesse this morning. Jesse has maintained great contact with Mr. Oleg, and they know the court dates that are coming up. I believe that it's on September 9th in front of Judge Donacchio. Those are set for pre-trial, Judge. I will note this is an allegation of theft of food products from IGA. No problem staying away from IGA. We are going to get him connected with some services so this kind of issue does not come back, Judge. He is open to that. I have a good address, good contact information, not just for himself, but also his wife here in the city. I think that this might eventually roll into an Andy Shangling situation.
based upon Mr. Olay's previous military experience over in the Ukraine. So I think that that's going to be the end route. I'm seeking a supervised OR bond based upon everything that I have told you.
What is the bond on, does he have a bond on the cases with Judge Janacchio or
I
is
would,
it OR? Do you
I
know?
would assume they are either OR or supervised OR. I don't know if he was on an EMD. Obviously, that would have been taken off before I had met him.
No,
So
I don't have anything.
I do not know the answer to that.
From the state?
Your Honor, I would be asking for a stay away from IGA. Other than that, we'll defer.
OR plus stay away from IGA.
Thanks, Judge.
Carpenter,
Go. Only if I get this one. Cool. You good, buddy? Or, all right. Good. Covered. Yes. I think we're right in the middle of your attorney is gonna be up there. Wait, no.
Not really for Mr. Carpenter, Your Honor.
pass the bond.
That's the bond area. There was one prior failure to appear. Denies the allegations. He's not going to be able to make a cash bond. He has good family support. He's been working in construction for a family kind of off and on. That's how he supports his children. The prosecuting witness in this case attacked the mother of his children and then tried to steal his car. His ultimate goal was to get her out of the car, not to do anything else. So he denies any other allegations in this case. So we'd be asking if you would consider, he'll stay away. There's going to be no issues with that. But he's just not going to be able to make much of a cash bond. A nominal bonder if you consider an SOR.
From the state.
Your Honor, I would be asking for a stay away from the prosecuting witness in this case.
OR plus jurors if requested. Gray, or Gay,
One second, guys.
is this the person from the other case?
Yep. Myself.
I think it
I got it. Yes, sir.
the one who had the, yeah.
Cool.
Yeah,
We're gonna
right.
go home eventually, we're not, and that's still not detailed, right? Bomb.com.
Not guilty for Mr. Gay, Your Honor.
Pass the bond.
Excuse me. He does have 7 failures to appear on, but I see no prior record. I think those came through some type of traffic. But he doesn't have any type of prior record. He denies these allegations. He's lived here since he was 12. So he has family ties. He's going to show up for court, full-time employment. The prosecuting witness in this case was throwing like an open bottle of soda into his car and food into his car. He was trying to get her to stop doing that and get her away from the car. Then he got back in and proceeded to leave. He didn't assault her. He's trying to get her to stop damaging his car. So we'll be asking for, we can consider an SOR bond in this. He will show up for court.
From the state.
Your Honor, the allegations are that the defendant chased the prosecuting witness, grabbed her, violently shook her, and threw food items at her. We would just be asking for a stay away from the prosecuting witness.
OR plus EMD plus a stay away. The EMD is because of the 7 prior failures to appear.
You keep those as open hour, Your Honor.
Yes. Jackson,
Your Honor, if I maybe heard this real quickly, he was saying that he had those prior failures to appear because he didn't have a vehicle. His forklift job might not let him work if he has the EMU on him. I understand he has those failures to appear. I don't think that's going to be an issue. Would you make any consideration as to not putting that EMU on him at this point?
I'll do an alternate cash bond, but I'm not doing straight OR because it's 7 failures to appear.
We'll talk about that later.
thousand anyway, or alternative, or EMD.
So that's all that's in this.
Jackson,
Jackson.
Disorderly. I think we have this one worked out, Your Honor.
You're not crazy. I saw you yesterday. You're a lot better. How was you were a lot better than you were yesterday. Well, I'm back. I was there.
Your Honor, currently charged with a disorderly conduct, fourth degree misdemeanor. We worked it out with the state. We're prepared to enter a guilty plea as a minor misdemeanor charge.
Ms. Jackson, a guilty plea is a complete admission of guilt. This is a minor misdemeanor. Maximum possible penalty is a $150 fine plus cost. On the original charge, you have the right to a trial to the court, to a jury trial. Knowing your rights, the maximum possible penalties. Do you want to maintain a guilty plea on a minor misdemeanor disorderly conduct?
Yes, sir.
Counselor, do you waive and stipulate?
Yes, Your Honor.
That includes waiver of service of the new complaint on the amended charge and arraignment.
Yes, Your Honor.
Guilty mitigation.
Mitigation, Your Honor, she did spend the one night in jail. This is a drunk disorderly. There's no excuse for that, but that's all that this is. We would ask for credit time served.
Anything from the state?
No, Your Honor.
One, credit one, remit the fines and costs. McLean,
All right, young lady. Absolutely. I know you.
Losing my voice.
You're coming. You guys are.
how much longer we go?
Not guilty for Mr. McLean, Your Honor.
All right, is this a first ever?
I have it as a first ever.
Yes, Your Honor.
And test,
It's a refusal.
My understanding is he
Acc-
did do the field sobriety.
accident,
No accident.
FRA,
March, no.
You have insurance.
And there is an ALS in place.
He does have insurance on the car, Your Honor. We'll get that shown at the proper time.
this is a first ever OBI. Is there anything, and there's no failures to appear, is there anything from the state?
No, Your Honor.
OR. Miller,
Those are hot, right?
Yes.
Go. Grab your hat and left. Miss Miller. Miller. Right in the middle, is your attorney.
Not guilty for Ms. Miller, Your Honor.
You got enough time, you're good. Let me see it.
all right.
Asked to bond, Your Honor. She has no prior failures to appear. She denies the allegations. Speaking with her, she's not going to be able to make a cash bond. Ultimately, these are nonviolent charges, lifelong resident. She just had mental health issues. She's connected with GCB. Because I'm appointed on this, that gives me the public defender resources. I just need to get her in touch with the social worker on this case, so that way I can get her to maybe guest street and back in with GCB. I'd be asking for you to consider an SOR bond on this, or a nominal bond that I can help her get out on.
From the state,
Your Honor, based on the complaint, it looks like the defendant was, they stated in the company of the protected party located at the protected party's residence, looking for a bond.
I think it was gonna be one of those allegations where she
Yeah.
provided over, but.
no record, no failures to appear, OR. Hot,
Thank you, Judge.
You were going hang left, huh?
Good morning, Your Honor.
good morning.
Miss Potts.
Good afternoon, on behalf of Ms. Potts here.
Ms. Potts has one misdemeanor, 3 prior failures to appear. Is there anything from the state?
Just asking for a stay away from the Golden Dragon.
Not unless you want to. OR plus stay away from Golden Dragon.
Happy not to. Give it all. All right, go ahead, keep in contact. Okay.
Stevenson,
Judge, my understanding, Mr. Stevenson, refused
That
to
hallway?
come down so that
Go on.
we're waiting one more day until tomorrow.
You good?
That's for.
Alright, continue to tomorrow, defendant's request. Unger Bueller,
Yes, sir. Come on in. Ready, one, next to yours. You got something on here?
Mr. Miller, do not guilty plea. As upon his behalf, Judge, he is 38 years old, a lifelong resident of the area. 48 years old, sorry. He would like you to know that he is getting into sober living. He's actually started the assessment at Linear. Has GED from Live Oaks. Misdemeanor asking for an OR. Oh, Judge, no more.
from the state.
We'll defer, Your Honor.
So it's 10,000 now. I will reinstate it back to what Judge Bouchard had it at, which was 5,000 anyway. Or alternative, OR EMD lockdown to Lemire, and only a Lemire rep can pick the defendant up from jail. They can do everything. Vinegar,
Good, hang left hallway.
Judge, for the record,
Mr.
Maya Henderson already represents Mr. Vinegar, so designating her. But I will address bond with him, so give not guilty plea. I will just note, he does have some college from Southern Ohio. He is a Marine veteran with an honorable discharge. We're gonna try and get a hold of Greg Street to see if he can get him into some services perhaps. I do see he's got a pretty terrible record, I'm not gonna deny that. But he can't make any kind of a money bond, so we are asking for an OR. Maybe we'll be able to do it in the alternative.
from the state.
Your Honor, the defendant does have a very lengthy record. I would be asking for a stay away from Hortons, a stay away from Walmart, as well as a monetary bond just based on his criminal record.
There are 112 misdemeanors, 7 prior failures to appear. I will keep the standard bonds on each one and add EMD. It does not look like Mr. Vinegar actually has ever been on EMD. So the standard cash plus EMD.
I just know that I have 112 classes, come 105.
You know?
Depends on which way you look at it.
It's gonna keep my mouth shut. Zealous advocacy. All right, West.
Mr. West here is going to be entering a not guilty plea, Judge. As bond, I do see that these are cases, but I would note they were from 2019 and 2020. And then that kind of cuts both ways. On the one hand, he hasn't been in court for a while. On the other hand, he has not gotten in any trouble in the past 6, 7 years. He would like you to know he's actually got a really good job. He works for United Hearts as a caregiver. His mother and both of his grandparents. He was actually picked up at the hospital where he was taking care of his grandmother. She's, as he indicates to me, she's on the hospital right now. His mother is actually getting out of the hospital, hopefully today. She had recently had a stroke and a seizure. He does take care of her. He is very apologetic about this. He indicates he came to court 3 times early on because he was having some issues dealing with a lot of different things. Pretty minimal record. So despite the KPS, we are asking the court to consider no bond.
Anything from the state?
Asking for today within Target and Menards.
So the trial judge, Judge Johnson, specifically stamped no reduction on his bond. So it will be the same bond as $1,000 anyway on each count. What? Yes. Franklin, Jeff Webb.
Very slow. He's maybe take a couple minutes coming out here. He walks very slowly. He's got some brain issues or feet issues. He's also hard of hearing. So. This was the judge order. I didn't have that information. I didn't see it.
I don't see any orders.
It will be a not guilty plea. Oh, I'm sorry. We would like to enter a guilty plea on the standalone open container. 1 of 4 or 5 please. City.
Mr. Jaquette, a guilty plea is a complete admission of guilt. The possession of an open container is a minor misdemeanor. Maximum possible penalty is a $150 fine plus cost. You do have the right to a trial. Knowing your right to trial, the maximum possible penalties, do you want to maintain a guilty plea to possessing an open container?
He's shaking his head, yeah.
Do you waive and stipulate?
We will, thank you.
Finding
I
guilty?
just talked to him about it in the back. That's what he wanted to do.
He's been in one night? Anything from the state?
No, Your Honor, thank you.
1, credit 1, remit the fines and costs.
On the remaining matters, Judge, will be an not guilty plea at this point. Only thing I would note, Judge, is there is an M3 in here on the 6649. But if the court looks at the allegations here, it was urinating in public, which I'm sure the court is well aware is not public indecency under the statute. It may be disorderly conduct, according to the legislative comments there. So I just like the court to take that into consideration. I would also note, Mr. Jacquet and I have talked about getting him into some alcohol treatment. We'll try to work on that. So these are all pretty low level M4 for minors. Got a pretty minimal record. I do show some failures to appear, of course, but asking the court to consider an OR on these.
Anything from the state?
Your Honor, I would just be asking that no alcohol be admitted.
So Judge Harris set these bonds about a month ago. It'll be the same bond. They are reasonable 10% bonds. There's, except for the open container, did an OR on that, that'll stay OR. The other bonds will be the same bond. Brittany Brown, Gary Martin, Jacqueline White. Okay. set an OR bond for Mr. Martin
No, that's all it.
last night. He's here today. Is there anything from the court? I believe what was provided to me last night was that there's no record, no failures to appear, and this allegedly happened in his backyard.
Nothing from county.
OR,
Okay, please be.
not guilty. All right. Are you Miss White or Miss Brown?
You're
Okay,
gonna follow your counsel.
all right. Good morning, Miss White.
Yes.
All right, yes, these were habeas bonds that have already been paid, so it'll be the same bonds. And then on the new charges, those were paid as well. All right. It'll be the same bonds that you already paid, Ms. White. You'll go to 117 to get your next court date.
Can I, because I had Jeffrey Wood as my lawyer, but he's in Indiana going to trial, so, but he wanted me to go ahead and see if I can get the driving part, because that was 2 years ago. I haven't gotten in trouble or driven. I didn't even know that existed. They gave me a court date, but it was Juneteenth, which I came down, but the courthouse was closed. And then when I called Corinne, they said I should get something in the mail, and I never did. So, but I just wanted to see if I can get that done with, possibly.
Is there anything that the state is willing to offer on that?
If she wants to plead the driving under suspension, it's an unclassified, we can dismiss the red lights violation.
All right, so Ms. White, what the state is offering is to allow you to plead guilty to the driving under suspension, which is an unclassified misdemeanor, carries a maximum possible penalty of up to $1,000 in fines and costs, up to 500 hours of community service. You do have the right to a trial. Also, when these go to the trial judge, sometimes if you are able to get valid between now, if you're not, and the time that you get to the trial court, sometimes they will dismiss those charges. So I don't know where you are in that process, but that is also an option that is available to you. But if you want to maintain the guilty plea, you certainly can to resolve it today, or we can send it with the other cases to be set out for trial.
Yeah, I do want to get it resolved, because when I tried to pay the reinstatement fee, they said I had to get it done first. I have for my daughters in Mount Notre Dame and Reading, my son's at Colerain High School, they don't get bused, it's been a mess, so I really need my license.
All right. Can I have the facts, please?
On or about April 18th, 2024, or sorry, yes, 2024. In Hamilton County, state of Ohio, the defendant operated a motor vehicle with a driver's license under a license forfeiture suspension in violation of Ohio Revised Code 4510.111. There was no accident. Insurance was marked yes.
How much are your reinstatement fees?
I think it was like $75.
And that's all you have left?
Yeah.
Fines and costs remit, FRA compliance. Where is Cornell, will you make copies of these? Go through that exit door right there and just wait a minute so you can get copies of these you can take to the BMV so that they can see it's been resolved.
Yes, ma'am.
All right, and then the same bond on the others. All right, thank you. And then on Brittany Brown, KPS 2000 at 11:01 a.m. Second KPS. Oh. Do you have the jacket for that?
Pretty rough. Yes.
There's a note on here that the defendant pled to the B charge. Does it have anything, was it a 1-for-1? I just have a note on here that she pled to the B charge 8/23/23.
I I only have the B charge as well. The A charge, it looks like
That's the one that I have.
was a non-compliance, but yeah, she pleaded the B charge. If, we can just dismiss that for plea, if we're able to do that.
Dismiss for plea. That is the docket.
Is it time for bond?
Thank you. 7.
Yes,
And then Your Honor, I did an entry of dismissal for a traffic case where the victim is now deceased, if you would be willing to sign that.
Yes. Have a good day. You too. Thank you.